Much. I did figure out how to share my screen. Thanks so much for being here, everyone. It is great to see your faces. As Katerina mentioned, I am an education lawyer, specifically a higher education lawyer, which is really rewarding work. I'm not defending the rich and greedy. I used to do that. Wonderful, well-meaning rich and greedy people at a really big law firm. And I'm pleased to see the faces and names on the screen today because when I started at that law firm 26 years ago, it had 800 attorneys and one female partner. So it's great to see your faces today. The crowd has changed a little bit. I focus not just on higher education, but in two spaces where the work is even more rewarding. One is in student funding, so scholarships, financial aid that helps get access to people who may have some financial barriers to higher education. And the other is in academic medicine, where not only do I get to work with people who are helping people, but people who are actually helping people who are saving lives or who are doing it themselves. And that work involves things like working on residency programs and accreditation for academic medicine programs with a lot of nursing schools and that kind of thing. So that is my practice. That's a picture of me. Today, I think we can be informal. There aren't that many of us. I do not know everything, but you are welcome to jump in and ask me a question and we can explore some of the contours around those open questions in this new area and sort of changing area around consideration of race in providing opportunities to participate in healthcare education programs. I will focus a little bit on residency programs because that's where most of the work has been done that relates to healthcare programs in terms of creating extra diversity. A lot of that work was done before the Students for Fair Admission decision, so we have to consider that when we're looking at the work that was done there. But we'll go over what the decision says. I know that you all can read. I'm not a constitutional scholar. I'm really focused on helping clients figure out what to do. I've learned that academic deans aren't necessarily interested in picking apart the equal protection clause. So I'll set the groundwork, but we won't go deep in the weeds there. We'll talk about what the holding was, what the practical implications are, and provide some examples for what different institutions have done to meet their goals around diversity and their needs around diversity depending on their circumstances. And we certainly have time for Q&A at the end. I can talk at you for 45 minutes. But again, please jump in. I really want to focus on what you're interested in this area. So to talk about Students for Fair Admissions, let's break down the case a little bit and some of the background. The key laws at issue were the Equal Protection Clause, which prohibits discrimination by government entities based on race, and then Title VI of the Civil Rights Act, which requires that no recipient of federal financial assistance can discriminate against individuals in selecting them for participation or providing opportunities in any program or activity providing federal financial assistance. So that's not just traditional educational institutions that are receiving money from the Department of Education. That's almost all healthcare entities receiving funds from CMS or NIH. So they are all subject to Title VI, of course. And then, in the general discrimination space, of course, you're subject to other non-discrimination laws in employment like Title VII. Notably, Title VI is like Title IX, which prohibits sex discrimination in education programs and activities. Again, it's not just limited to education, Department of Education funded programs. So if you don't have a Title IX coordinator, let's talk after this because your healthcare institution probably is subject to Title IX, even if you're not a school with fraternities and things like that. So I said I wouldn't talk too much about equal protection, but just a refresher from law school, from your con law class, different classifications are subject to different levels of scrutiny by courts when they're evaluating whether they're allowable under the Equal Protection Clause. And for race, and national origin and alienage generally. The government has given itself an exception for alienage if it's regulating it. Those are all subject to strict scrutiny. And sex has a lower bar. That's why in our programs we can discriminate based on sex in education programs in some limited circumstances. We don't have to meet that stricter equal protection test where we're talking about compelling interests and whether they're narrowly tailored, which we'll talk about in a minute. So the Students for Fair Admission case, which focused on the Equal Protection Clause in Title VI for Harvard and the University of North Carolina, was issued in July of 2023. And before that, the Supreme Court did allow education programs to consider race in admissions in very limited circumstances. So you could consider race in education admissions to address a compelling interest. And the compelling interest that schools would give, and that the courts kind of blessed beginning a long time ago, was this idea that having a racially diverse student body created some education benefit to the educational institution. And the thought, I think, behind allowing that was also that courts typically defer to education programs in setting their academic requirements. So some of the past case law would say, okay, you're an academic institution, you get to decide what matters. And we agree that a racially diverse student body is a compelling interest. But over the years, that got narrower and narrower and narrower. And right before Students for Fair Admission, almost an insurmountable threshold, but it said schools could consider race if they did it on an individualized and narrowly tailored basis with specific, measurable, and documented goals. So we really had to have a written plan. We had to have a lot of data. We had to have a lot of evidence about what our goals were and how we would meet them, where there were no race neutral alternatives. So we needed to show that other approaches hadn't worked as part of a holistic review process. So we couldn't just consider race. We had to consider a lot of other factors. We could never have quotas. And according to Students for Fair Admission, we had to have a limited duration. So we had to have this achievable goal.
Hi, Annie, just to interject real quick. I don't know that I'm able to see the slides changing. If you are moving through slides.
Does that help?
Let me see.
You can't see them. Let me stop sharing and reshare.
Yeah, and if you continue to experience issues, I have a copy of the slides here as well that I can share. So just let me know. We'll try it out.
Now I have, let's see. Give me just a second. I'm glad you told me. And that happens sometimes. I feel like I had something in my teeth and nobody told me for a minute.
You were on such a roll. I did not want to interrupt.
I told you I could talk at you forever. Okay, let's try this. Let me resize it. Can you see that now?
I can see slide 1, slide 2, slide 3. Okay. Yes, so now I'm seeing them change. Okay. I think we're good to go. I'll let you know if that stops.
Okay, it's much more fun with the pretty graphics.
That's what I'm saying. We have to share the slides.
I'm also on the AI team, and I used a little bit of AI to create my graphics.
They look great. All right, we're all set to move forward.
Okay. So the Harvard and UNC had admissions practices that considered race to some extent. And I'll talk about what they did because I think it's instructive to see exactly how narrow the court wants us to be. But they both considered race, and Students for Fair Admissions, which is a civil rights group, challenged Harvard and University of North Carolina's admissions policies, saying that they violated Title VI and the Equal Protection Clause, and ultimately ended up denying unfairly and in an illegally discriminatory way opportunities to Asian students based on their race. They were saying if they hadn't considered race, far more Asian students would have been admitted. So let's look at what these policies did and what these practices were. So these were multi-step decision-making processes. And for each school, race was considered at various steps. So at Harvard, you have a first reader who of an application who would consider race in this sort of overall scoring. The application would get passed on to a subcommittee that reviewed applications by geographic area, but they could also consider race. And then you had a full committee review, and the committee would discuss the race breakdown of applicants. And then you'd have a tentative acceptance and a vote. And then there was a final stage, they called it a lot process, which included consideration of things like legacy status, is this person an athlete, financial aid eligibility, and race. So that's a pretty typical competitive school admissions practice in my experience pre-SFFA. We worked with a number of sort of the top US ranked institutions on admissions, especially after the admissions scandal a few years ago. And this is, they're trying to balance their class. They're trying to get a few students from each group. And it's almost like a murder board diagram where they're trying to get just the right amount of students from each group. And they would consider racial classifications. And UNC was similar. It's a bigger school, which is why I think it was a little less involved, but it would consider race at various stages. And ultimately, race could make a difference in whether a student got in or not. And the arguments on both sides were, the Students for Fair Admissions argument was that this should be a meritocracy. It should be based on objective factors that don't consider race. That it violated Title VI's prohibition on race, and same with equal protection. And that because there are a limited number of slots, unlike another institution that might admit, a wide variety of students or a much higher number of students, that at these particular schools, it was illegally harming Asian American applicants. And then Harvard and UNC said, they brought up this diversity benefits in education argument. They said, it's up to us to decide what our students need. We should get to rely on what this court has ruled before as a compelling interest. Our programs are narrowly tailored. We have evidence. They had lots and lots of evidence. If you look at the First Circuit opinion from the lower court around why other programs wouldn't work, historical discrimination of their institutions, and the careful work they'd done to put together their plans, and that they wanted to rectify historic discrimination. So they really did, do as close to what I think you could have done to meet the court's prior guidelines on what could be considered. And the court said, nope, it's not narrow enough, that this compelling interest or this interest in education benefits of diversity is not compelling enough. It's not measurable, it's too smushy. You can't put an endpoint to it. Justice O'Connor years ago said we won't even need to consider race in education 25 years from now, and it's been 20 years and we haven't made any progress. So essentially, no, you can't do this. Your programs, as they're written for, remember, these are undergraduate admissions for traditional programs where the justification by the schools was this education benefits of diversity. The court said, no, that's not enough of a compelling interest and your plans don't otherwise fit our requirements. The court did, though, first of all, it didn't overrule its prior holdings, so it said. And it did expressly say, okay, you can't consider race as race, but you can consider the impact race has had on someone's life, how that might have developed certain characteristics or provided them with certain experiences. And if they happen to mention it, say in an essay, you can consider those characteristics as long as you're not excluding them or giving them a preference based on race. So it says nothing in this opinion should be construed as prohibiting universities from considering discussion of how race affected their lives, be it through discrimination, inspiration, or otherwise. So if you were saying, I'm a person of a certain protected class, and I've had to survive microaggressions for my whole life, and that has helped me become more tolerant or more patient, and I've built skills that allow me to function in a world that's going to keep presenting me with these issues, and that is ultimately going to make me a better physician. That is something that could be considered, as long as you would consider it for someone in a racial minority in the same way you would for someone that you wouldn't classify as being in a racial minority. So it doesn't prohibit facially neutral policies that have an intent for diversity, as long as there's a legitimate race neutral rationale. So what the court was saying here is that you can't have proxies. I would strongly recommend against having sort of one-for-one proxies for race. Certainly you couldn't consider an applicant's membership in an organization that was only open to people of a certain race, because that would seem to come as a one-to-one proxy. But you could consider broader policies of having general diversity or geographic diversity or socioeconomic diversity, as long as you have that race neutral rationale, even if it had an impact on racial diversity ultimately. And you can recruit individuals from a diverse applicant pool. So you can do still targeting recruiting, and we'll talk about some more examples of what you still can do. You can still have educational programs that teach the value of diversity, as long as they're open to everyone. You can still have, of course, and you still must have efforts to address prohibited discrimination in your programs and activities. And the court said something that I think is really important for this group, which is they said that for now, they're not going to talk about the military service academies discrimination or consideration of race in admissions. And in fact, the Supreme Court just last month denied cert in a case challenging those military academies justification for considering race in admissions. And I'll touch on that a little more in just a moment. So what's up next? I think we're going to have a number of lawsuits against institutions that are trying to implement race neutral policies that are challenging them as just having a proxy for race-based classification. So if you draw those race neutral policies too narrowly, you're going to end up with a proxy challenge. I think we'll look at scholarships. Frankly, as a student funding lawyer, I don't think that scholarships based on race have ever been allowable if administered by a recipient of federal funds. But we'll see more challenges to those. We saw a ton of challenges in the Title IX space to things like women in STEM programs, because why would we want to have those programs? I think we're going to see more and more of them. If any institution has a scholarship or a program that seems to give a racial preference, please check your website really carefully. I think we'll probably see a spate of litigation by people who are interested in sitting around looking at your website and thinking of challenges to file. Of course, in employment, we could see some trickle down there. You really can't consider race in employment, but I think, again, you'll see some challenges to areas where it looks like proxies. And
I can chime in on this one as an employment lawyer. We have seen some attempts to, through litigation, arguing that the SFFA decision somehow is applicable to private employers. The answer is it's not. The decision was under Title VI. Employers are under Title VII. And affirmative action plans are very, very different from DEI plans, which are what employers tend to have. It has always been in violation of Title VII to make any employment related decision based on a protected characteristic, including race. So we are seeing those arguments coming through. We're seeing some reverse discrimination claims where you have somebody from someone who's not from an underrepresented demographic bringing a claim. So usually white men in their 30s. But my perspective is that those claims are largely unsuccessful, and there is a higher standard that those plaintiffs have to meet to prove claims of discrimination when they're not members of an underrepresented class. So that could be an entire presentation in itself, but I did just want to chime in on that point that we are seeing some of that.
I'm glad you did. And it's interesting to me as an education lawyer, because often when courts are looking at, say, Title IX, which prohibits sex discrimination in education programs, they'll look to Title VII and analogize to it. So it'll be interesting to see whether courts do the opposite and analogize to Title VI in this setting, to the employment setting. So of course, Students for Fair Admission isn't the only thing that you're considering as you go about your day. You have to consider Title VII, of course, and some slightly different case law in that area. Importantly, Students for Fair Admission did leave a crack open to still consider race in admissions or other decision-making. They said, you can still work to remedy specific identified instances of past discrimination that violated the Constitution or statute, something about prison safety. And then again, that footnote on military institutions left the door open. And that's combined with some early 2000s case law that says in police forces, and this is circuit court case law, that you can consider race in hiring because, including from my favorite circuit, the Seventh Circuit, because there's a compelling interest in engaging individuals in the police workforce who can relate to the communities they're serving. And I think that one is super, super interesting in academic medicine because we have a lot of research. I won't pretend to fully understand the research. Some of it gets super academic, and there's competing research. But it shows that individuals who are treated by someone with whom they feel some sort of race concordance, they identify with the individual as being from the same race as them, have better healthcare outcomes. Physicians who are Black and brown or come from backgrounds that are low income or rural are much more likely to serve those communities when they come out of school. And those are certainly underserved communities. There's a lot of policy support for growing rural programs. So I wonder, I'm trying to get some really well-resourced institution to take on this argument and take on this risk, if given its mission, a healthcare institution could implement a program for the purpose of remedying these, what I can only presume are very measurable disparities in healthcare. Given all the research I see, if you just Google healthcare disparities, race, there's got to be some quantifiable measure of how many more physicians or healthcare providers we need from various races so that they identify with the healthcare populations that they're serving, so we can drive these better outcomes, which will benefit our whole community with a ton of trickle-down effects. And it seems like we could project, or at least the people who do this research could project, how long it's going to take to get us there based on our past experience with race neutral or even race considering programs, and narrowly tailor our programs to meet those measurements. And then as long as that military academy exception stays standing, argue that health equity is a compelling state interest. And that should transfer to Title VI as well for non-government entities, and consideration of race in healthcare education programs should be permitted. I kind of nerd out on that idea and I get really excited about it. So I'm happy to talk about it offline, but I think it's a great idea. And by way of background, the courts have said in the past that military academies can consider race, and this dates back to the Vietnam era where there were findings that officers with whom the people they were leading identified had better defense outcomes than situations where you had a white officer leading, say, minority troops. So that was the justification for allowing the military academies to do it. Again, we've got the police cases saying you need to be able to police your community. I think healthcare is very similar to that. And there's a great, if you also nerd out on that, there's a really good NPR politics podcast on why military academies are allowed to consider race. So not only do you have, the Students for Fair Admission and Title VI and the equal protection and your funder requirements, you've got accreditors. Of course, you have healthcare accreditors who also have their own standards, who want to meet diversity in workforce and community need expectations. The two key accreditors in academic medicine, or two of the key accreditors in academic medicine, LCME, which is the primary accreditor for allopathic medical school programs, and ACGME, which is the accreditor for graduate medical education, fellowship, and residencies, both require you to have diversity policies. LCME got called to the mat by Congress in last May 2023, and in its letter to the Committee on Education and Workforce, it said, yes, we do require diversity policies, but we allow schools to define that as they want. So, neither institution dictates how you must define diversity. I think neither institution dictates that you must violate students for fair admission, but both are active in this space of encouraging diverse healthcare workforces. You also have funding agency definitions. I've been watching these pretty closely, and I'd be interested if you've noticed any changes. Clearly, our executive administration at the federal level wants to support diversity in education and is not particularly pleased with this court's Students for Fair Admission ruling. So I've been looking, to see what your sponsored research agencies are doing, or what maybe your state funding agencies are doing. And I haven't seen a lot of changes. The one I find super curious is the NIH. So back in 2019, way before Students for Fair Admissions, they issued this notice of interest in diversity, and they defined underrepresented in medicine. And that does include things like socioeconomic diversity, but it also expressly includes race. In fact, that's the top category it's considering. And it hasn't pulled this down. It's pulled down past diversity statements, but it hasn't pulled this one down. But what it has done is, in its applications for funding, it's changed the language. So it had a number of programs that were aimed at building diversity in STEM, or women in STEM, or racial diversity in medicine. It's changed the applications on those to say that they are open to everyone, but individuals who identify as underrepresented in medicine are encouraged to apply. So it's taken that shift to having affinity groups that are only open to those who might be underrepresented in medicine, to allow still having those groups, but allowing them to be accessed by everyone. We have developing state laws. There are a number of states that prohibit consideration of race in admissions expressly in higher education institutions. A number of states that prohibit consideration of race in hiring and education in any state agency. Most of these are focused on state agency. A couple of them are focused on whether someone can get state funding if they consider race, or they have DEI initiatives. But there are a ton of them. 8 of them have passed since Students for Fair Admission. So if it's not clear from the news, this issue is really gaining some momentum. Wisconsin actually proposed a constitutional amendment that would prohibit your state agencies from discriminating against race in public education. It passed the Assembly on February 15th, but it would need to pass 2 successive sessions and then be ratified in a statewide vote. So it needs to carry some significant, it has to cross some significant hurdles to actually get passed. But like a lot of other states, Wisconsin has some pending legislation prohibiting consideration of race in public education. So it would be interesting, even if the Supreme Court said that in some cases you can consider race, say in healthcare, if a state passed a law saying you can't, certainly the Supremes would control as to the Constitution, but you'd still have to wrangle with that state law. The Departments of Education and Justice provided some guidance. I realize several of you are probably not funded by the Department of Education, but it is really active in this space. It's been as vocal as one could be, given that the Supreme Court ruled as it did in Students for Fair Admission, in sort of supporting schools in identifying ways to create diversity in their programs. And it issued in August a Dear Colleague letter, and then there's an evolving questions and answers resource guide that they published and include a number of specific recommendations for how to support diversity and examples. And I'll look at a couple of those. And I find these examples really helpful when I'm talking to healthcare clients about how to implement students for fair admission. I can certainly talk to in-house counsel about what the case says, but I find that when I'm dealing with the diversity offices, or certainly the research dean who happens to have diversity on their plate as well, that kind of telling these stories is most helpful to them in setting the parameters for what they can and can't do, and where the risk lies in the gray areas. So if we have someone on their application describe what it means to be the first Black violinist in their orchestra, that's okay. That's race neutral. We can consider sort of the characteristics that have evolved and the experience that they had, as long as we're not giving them plus points just for being Black. Or we have an applicant's account of overcoming prejudice when she transferred to a rural high school where she was the only South Asian student. Or a guidance counselor or other recommender describes how an applicant conquered her feelings of isolation as a Latina student at an overwhelmingly white high school to join the debate. We're celebrating her resilience, her ability to overcome hardship. Or an applicant's discussion of learning how to cook traditional Hmong dishes from her grandmother, and how that sparked her passion for food and nurtured her sense of self by connecting to past generations. All of those examples could be considered, as long as we wouldn't exclude a student talking about what it meant to be the first white violinist in the youth orchestra, or to be the first female student who learned how to cook dishes from members of their family. Let's look a little bit more of what you can do post SFFA, considering some of the practices that have been employed by schools in the past. Here's a list of race-neutral factors that schools have considered and tried to implement. We believe that these are all clearly allowable post Students for Fair Admissions. Sometimes when I talk to institutions about these race-neutral factors, which often rely heavily on kind of socioeconomic status, they'll say, well, that's not enough. It's not going to get us to the race threshold. And that certainly may be true, but I think it's a little less true in medical fields, especially medicine, where reportedly more than half of the students who are accepted to medical school come from the top income brackets in the country, while only 5% come from the lowest. 73% of successful applicants have a parent with a higher education degree, and only 20% of those parents of successful applicants are actually doctors themselves. So I think in medicine, the math is a little bit different on the impact focus on the race neutral factor of socioeconomic status can have. The idea of holistic review was expressly affirmed by the Supreme Court as acceptable as long as it doesn't consider race. So it's an idea really pushed by ACGME, the residency accreditor, and it talks about considering the student as a whole person. So we're considering their attributes beyond race, beyond protected status, to determine whether they're going to be good healthcare practitioners. There was one case that was decided by the Fourth Circuit before Students for Fair Admission, and it involved a middle school, this Coalition for TJ versus Fairfax County School Board. And the Supreme Court denied cert in that as well, just last month. And there, it was a middle school, it was a magnet school, and they had, in 1 year before Students for Fair Admission, 71.5% of their class, accepted class, ended up being Asian American, and 19% of the remaining students were white. And the school really wanted to change its racial diversity. So it adopted this holistic admissions policy, and it had a top 10% program. That's where it said that students in the top 10% of their middle schools in the area would automatically be admitted. And then it used a holistic approach for the remaining students and considered factors like family income, whether English was an applicant's first language, and it excluded name, ethnicity, race, and sex from those making the admissions decisions. So they couldn't see that. And the result was they got way more low-income students than they had before, and more English language learners and more girls. And the offers to Asian American students fell somewhere between 10 and 20%. And Black, Hispanic, white, and multiracial / other students saw their shares of admissions offers increase, although it didn't correspond to their percentage in the population. So the Fourth Circuit, first of all, found no proof of discriminatory purpose here, given that race was not considered. But it did still note that pre-Students for Fair Admissions decision, saying that you could consider the educational benefits of diversity as a compelling interest, but it only applied rational basis scrutiny to the plan because it found there was no consideration of race and no purpose, no demonstrated or documented or evidenced purpose that this was for purposes of changing racial diversity. Some promising practices that we've seen are targeted non-discriminatory recruiting. So you can go to, an HBCU, which admits more than only Black students to do your recruiting. So it's open to all students of all races, but you can target your recruiting as long as that recruiting program is open to all students in areas where you might draw a more diverse applicant pool. Same with targeted programs. I found this one interesting. So some medical schools have started programs for students who have an interest in rural medicine or an interest in serving underserved communities. And part of their admissions consideration is whether there's a demonstrated interest in serving those communities, which tends to draw a more diverse applicant pool. Top 10% like programs. If you're in GME, you might not have really the opportunity to say the top 10% of all these medical schools can get in, but you could consider, the top, if the applicant is within a certain top percentage, they might automatically at least get invited to an interview. It doesn't have to be an automatic offer. It could be some implementation of that. Of course, those clear goals and criteria so you can defend your program. A diverse committee seems to be very helpful in drawing more diverse applicants, more diverse interviews, more diverse successful candidates. Make sure you train them and provide support for them so that they understand goals that, of course, are not focused on racial diversity. They're focused on finding the most qualified candidates and not excluding them because they don't have things on their resume that typically exclude those who are underrepresented in medicine. Things like, did they belong to a medical fraternity? Are they a legacy? Do they have family members who are in this profession? Did they go to a top 20 school? Things like that can really limit your applicant pool and your successful candidates if you're relying on that too heavily. Same with test scores, although I'm not sure as a patient of doctors that I want you to completely ignore test scores, but try to limit consideration of that. And then you can have pipeline programs. We have clients who are reaching back to middle schools with their pipeline programs, trying to support diverse populations in taking an interest in STEM. A couple of examples that I think are helpful. They both started pre-Students for Fair Admission, but they have a lot of non-race-based factors that can be helpful. So the Penn program, University of Pennsylvania Family Medicine Residency Program, started the SHARP process, where it did consider those, test scores, clinical grades, recommendation, traditional factors, but it added a whole rubric that considers experience with marginalized communities, participating in community medicine, and demonstrated insight into the social determinants of health, which, of course, you might have more insight into that if you've grown up in a world where those social determinants of health were lacking. And then they did something that was interesting. They took resilience and distance traveled, which is basically perseverance through hardship, including things like systemic racism, which I think is a little bit risky post-CFFA to keep considering, and use those as multipliers. So if a student had either resilience or distance traveled, you would take their score and multiply it by 1.1 And if they had both, they would multiply it by 1.2. So that bumped them up in the ranking of candidates. And you can see here from the graphic that they made a lot of difference in, I missed my key, before is underrepresented, it's underrepresented in medicine is what we're showing here. So in interviews before implementation of the SHARP, we had 23% who were URIM by their definition, and then after 38%. And with matches, those grew like more than double. Is my math right? Almost double by implementing this program. It was first implemented in 2021. It took a couple of years to get up and running, and they did put a lot of resources into this, but it was really, really successful. And then UC Davis has an incredibly diverse class of 20 that started in 2023. And that was coming from a highly white male class just a few years ago. They have a really dedicated medical director who implemented this race neutral consideration. I suspect race was considered at least pre-SFFA to some extent. But they invested funds, they limited focus on test scores, they created a community college pathway program, they have a peer mentoring program, and you'll see, this class compared to many medical school classes is quite diverse. So looping back to those considerations that we talked about in the beginning, the pre-Students for Fair Admissions case law that the Supreme Court did not, it said, overturn, we still have, I think, room, especially in the medical professions, to maybe really carefully narrow and carefully document the evidence-based justifications and the timeline for programs that might consider race. And that would extend to programs that might consider sex, because if it meets strict scrutiny, it's surely going to meet intermediate scrutiny that's applied to sex. And so consider if considering race is important to your clients, and they have some risk tolerance, whether they want to be offered this option or consider the option of really going after that and challenging what some would like to say is the sweeping application of Students for Fair Admissions. It's clearly prohibited now to consider race directly in traditional programs where your sole basis is boosting diverse participation in education programs generally. Students for Fair Admission knocked that out, but we can still have these race neutral considerations as long as we don't have proxies, as long as our participation opportunities are open to everyone. And then there's that gray area if we're looking at areas that some might argue are proxies for race, or if we have that evidence supported justification for something that might be a compelling interest. It's totally untested, so don't say that I recommended that you pursue a program based on health equity justifications, but I think there may be room to pursue that. So that is my 45 minutes of talking at you. What questions can I answer? Or I'm really interested in what you're seeing at your institutions or what your clients are asking about. We got a ton of questions from our academic medical schools and research institutions right after this decision came out.
That's great. That was so interesting and thorough. And it looks like we do have a question from the audience. I don't have any context, but the question is, were there any changes to the University of Chicago?
I would have to look. I don't even remember. Were they considering race before?
I'm not sure. But I assume if they were, then they either have or they're in the process of it. Wendy, do you have any context for that question?
Yeah. Crystal, you might have some context, but she says, yes, they were considering race before.
Yeah, so I asked that question because my son actually applied to the University of Chicago and was admitted, and he is attending that school, but it was during this whole operational change and everything that was going on. Mm-hmm. And so we're always curious to know how it was impacted and what has changed, if so anything, at that location. And I know for him, he when we went to the events prior to him enrolling into the school, it was basically what you said. It was majorly Asian, and you saw very few people of any other, was Asian. Very few people who were African American. He was like one of 2 Latino guys who was there. So I'm just curious as to any of that has changed and if they've seen changes in their numbers as far as enrollment and applications and whatnot.
And I'll be interested to see how that plays out at that particular school. I also had a son applying in the last cycle right before Students for Fair Admissions came out. He did not get into the University of North Carolina, shockingly, as an overprivileged white male, despite what I think are his amazing qualifications. But he was a good sport about it. He was a very good sport about it, and he landed in a good place. But I'm really interested to see how these numbers will shake out over time. I think it might take several years before we see an impact that would allow us to argue that there actually is a compelling interest in having diverse educational populations. I think we're going to start tracking this. I don't know if he's an undergrad or med school or some other health profession, but the class that was admitted for fall 20, or the class that's being admitted now, will be the first class where it's clearly been prohibited to consider race. So, we're going to have to track that over at least 7 years to see what the outcomes are for medical school, and 10, 12, 15 years to see what they are for residency. So that unfortunately is going to take some time for us to see, but I know that institutions are changing their policies. I know their legal departments are encouraging their clients to change their policies, and they're getting a lot of pushback. I mean, there are diversity offices and deans and other people who are really upset that they're being told they need to pull race out of their definition of underrepresented in medicine.
Yeah. I think my hope is that resulting from this, there will be some creativity that spawns as a result of not being able to consider race, right? Because at least in the employment context, when we're talking about diversity, we're talking about every single dimension of diversity, right? With an emphasis on underrepresented individuals who fall under underrepresented demographics, but we're talking about diversity of thought, diversity of experience, like you said, diversity of geography. Where were you born? How many languages do you speak, right? Where did you go to school? Like, those are all things that make you a diverse candidate when you're looking at it at the broadest sense. And so I'm hoping that, as these academic medical centers are working through how to be in compliance with this new decision, that they're coming up with these creative solutions that may actually result in them bringing on even more racially diverse candidates than maybe they had when they were considering race in admissions. I also have a follow-up question for you, Annie. So I noticed that, a lot of these universities or anyone who really has an admissions procedure that they're going through sometimes considers legacy. And I'm wondering if there have been any lawsuits alleging that that is effectively race discrimination, right? If you're looking at who has historically been admitted to these very, very old institutions, it's going to be people of Caucasian descent. And so have you seen any lawsuits come through the pike where they're saying, if you can't consider race, you can't consider legacy?
I believe that there are. I have given up tracking litigation, but I know that there are schools that are changing their policies. I mean, lots of schools have decided to keep their test optional policies. Lots of schools have, I won't say lots, but many schools have dropped their legacy policy. And I think the schools that haven't would say that there are reasons to keep admitting legacies. One of them being, speaking frankly, legacies tend to give more money to the school when they graduate. They tend to make more money when they graduate, probably because of systemic racism and historical racism, but they're going to give back more money. And the schools would say, if they didn't give back that money, we couldn't give out as many scholarships. There are very, very, very few schools that can be need blind. And most of them are tuition dependent, and they rely on families who can pay cash, so that even if racial diversity and other diversity is a huge mission-driven goal for them, they can't support scholarships, and they can't support that goal unless they're admitting students who are more likely to pay cash.
Sure. Yeah, I appreciate you being candid about that.
It
Did
is-
we have any other questions from our audience for Annie?
Annie, you mentioned that Title VI programming are really subjected, anything that's funded through Title VI, so CMS, DHS. So we're focusing right now on the medical centers. Do you think this will go down to like undergraduate or other educational opportunities?
Say more about that. I'm not sure I understood your question.
Yeah, so you were focusing primarily on like the medical schools or the residency programs.
Yeah.
Will these same laws hold true to like undergraduate programming?
Yeah, I think they clearly do. Students for Fair Admissions was about undergraduate admissions. So that would include, all your undergrad programs, really any education program.
Mhm.
Again, I think there's room to argue that it's depending on your what you're positing as your compelling interest. There's room to argue that your program might be different. But yeah, it definitely applies to the undergrads. I think they're feeling the biggest impact.
Yeah.
Without a doubt.
You also mentioned that scholarships could also be affected. So let's say, students get into the program of their choice and the scholarship funding, let's say it's private. So for example, it's from a donor to a school or a program, Department of School of Education, for example, we want to donate funding to. Do you think that those scholarships also potentially could be affected?
I think those scholarships, if they are race restricted, have always been prohibited. I don't think that's a change in the law if your school is administering them. Now, if it's a private organization that is selecting the recipient, that is, and all they're doing is writing a check to the school, I think that's okay if that private entity is not regulated by Title VI. I think you can take their money. But a lot of times private entities or donors don't want to do that. They don't want to sift through the applications. They don't know what your program needs. So they want a department to make the decision. There's some room for doing that based on sex under a really cute arrangement that falls within the Title IX regulations. But I don't think there's room for doing that based on race. I don't think that you, as recipients of federal funds, can administer a scholarship program that excludes individuals based on their race or gives a preference based on race. But I would love for someone to raise an argument to the contrary. Which is why when we're advising schools about gift acceptance agreements, we recommend that you always build in, if we determine in our reasonable discretion that administering this the way you wrote it is illegal, we can do the next best thing.
Amazing. Thank you so much, Annie. I see that's our time, so I'm going to turn it over to Alexa to close us out.
And I'm actually going to thank you so much, Annie. I appreciate all of your insights. I actually have a couple more questions, so hopefully we can connect with you offline to ask those, particularly regarding kind of planning for the future based on the health equity points you made in terms of our medical professionals. And I was just curious to know if any of your clients that kind of started planning process to see how they're going to address some of this moving forward. So if we could get any insight you have to that question offline, then we can share with our members. That would be great. I have to jump off for another commitment, but I'm going to turn it over to Wendy, who's going to update everyone on our upcoming events and kind of close us off for today. So thank you so much.
Great. Thank you so much, Attorney Cartwright. We really appreciate your time and expertise. And as part of, as a co-chair for education and programming, along with Crystal Landeros, we really appreciate you coming to our NALHE event today. So thank you so much for your expertise. For the rest of our members here today, we will have our next programming and educational event on Wednesday, May 8th. That will be in person and that'll be in Madison. So please stay posted for more information. We're excited to bring you some more educational events, and we're excited to meet in person in Madison. Thank you so much, Attorney Cartwright. Have a great day.